Very good. Good afternoon to all of our attendees. We appreciate you taking the time out today to welcome Kim Shaw Elliott, an ERISA attorney, who's going to be doing steps to maintaining ERISA compliance today for broker-dealers and investment advisors. Really happy to have Kim on today. Kim and I have worked together over the last couple of years. Kim and I have done things regarding 316, and Kim and I are also going to be at the Center for Due Diligence conference doing a session called What You Need to Know About ERISA 316 Services, Legal Insurance, and Marketing. So I want to welcome Kim. Kim has represented broker-dealers, investment advisors, and insurance companies. She's been on all facets of the broker-dealer and investment advisors space, and so she brings real-life knowledge of what your broker-dealers and investment advisors do on a regular day basis, as well as defending claims on my side for claims made against advisors and broker-dealers. So without further ado, I welcome Kim to start the presentation.
Thanks very much, Gary. Appreciate the opportunity to be here, and thank you all for joining us. Gary has listed here a list of other resources that might be available to you, so if you opt to receive a copy of this presentation, you might want to take a look at this page. What we wanted to accomplish today is hopefully a discussion about what the current environment is in the ERISA space as it relates to broker-dealers and investment advisors, and discussing a question that Gary and I have debated quite a lot and have a paper out there on this topic, but why would it be important for you to have a well-crafted agreement that relates to your fiduciary and your non-fiduciary services to retirement plans? We also wanted to talk about what's all the hoopla about the 408B2 disclosures, and if you are considering stepping up to becoming a 338 investment advisor, what are some of the things that you should be considering? And lastly, we want to just take a quick moment and talk about what might be on the horizon for retirement plans. So with that, we'll begin. First and foremost, I think it's important for you as broker-dealers and advisors to really understand the regulatory environment in which you're working. If you're not aware, the Department of Labor has added 1,000 new enforcement agents to their regulatory force, and they are out there looking for issues with retirement plans. It's important that this is on the radar screen for all the regulators that relate to investment advisors and broker-dealers. So that includes not only the Department of Labor, but the SEC and FINRA. And if we take a moment to look at this, some very interesting statistics based on the results that the Department of Labor achieved just last year. In 2013, 73% of all Department of Labor investigations resulted in fines. So that means for almost three-fourths of all cases when the DOL comes knocking at the door, somebody's going to pay money and somebody's in trouble. Now, also what we've learned is that statistically, when this happens for whatever reason and whatever the issue is relating to that plan, in most cases, the advisor supporting that plan is then fired. 88 indictments were issued last year, and the department initiated a new program called the Fiduciary Service Provider Compensation Project. So they're looking at how much you and your firms are being paid, and it is an area that is under intense scrutiny right now. We know that there is an enforcement priority on anybody who is acting as a professional fiduciary, and certainly that would be in your capacity as an investment advisor or other support to the plan. The DOL isn't alone in this effort. The SEC has identified retirement vehicles and rollovers as one of their examination priorities for 2014, and not to be left alone, FINRA has also joined in and added rollovers to their examination priorities. And for those of you that saw that, there was a very important announcement regarding rollovers from FINRA earlier this year. So with all of that, it's a very, very active regulatory environment and one that we want to be very much familiar with. We also need to keep in mind that this is a very specialized practice area. Providing services to retirement plans really requires expertise in a lot of areas. And I think typically we think of ERISA professionals as those that understand how qualified plans work, know how to draft plan documents, know the discrimination rules. But in this area, when you're dealing with broker-dealers and advisors, you also need to understand how those activities relate to the FINRA rules and the SEC rules. So it really is a multi-practice area. So all of this relates to who is a fiduciary, and that's a primary question that many of you ask, and it's important for you to understand when you become a fiduciary. Whether one is a fiduciary is what's called a functional test, meaning it is what you do, not based on what you say you may do or what the title is given, what particular title is given to you. There are three ways in which you can become an ERISA fiduciary. One is if you have discretionary authority regarding the administration of the plan. And these typically are the named fiduciaries. It's the plan administrator, the plan trustee, typically the plan employer operating in a way that deals with the management of the plan. One can become a fiduciary by providing investment advice for a fee, and we're going to look at that in a little bit more detail. But this is where we're going to find most of our investment advisor representatives operating in this sphere when they're giving investment advice for a fee. And lastly, you are a fiduciary if you have discretionary authority over plan assets. Now note that this means any discretionary authority. So if you inadvertently do it, even though you weren't authorized by a plan document to do it, or if you are doing it even not in a 338 capacity, you are an ERISA fiduciary. And the interesting thing about this to keep in mind is ERISA, of course, deals with a lot of numbers, and we as ERISA practitioners often cite to Act sections and Reg sections, which may be a little bit confusing to those that aren't well experienced in this area. But for a little additional insight, a 321 relates to the fact that Section 3 of Part 1 of ERISA is where the definitions are. And the 21st definition is that of fiduciary. So all 321 means is that you are a fiduciary as defined in ERISA. Now in practice, most of the time, 321 is differentiated between 338, and 338 deals with the investment manager. But in a technical sense, since a 338 has discretionary authority, they really are a fiduciary as defined in Section 321. So what does the investment advice for a fee provision really mean? And we all know that the Department of Labor has, with great effort, tried to change this definition. It was originally issued in regulations issued way back in 1975, and the Department of Labor felt like it really needed to be changed. But it was proposed, reproposed, put into final regs, withdrawn from final regs. Latest word is that they're going to be reissuing the definition in January, but I'm hearing that that's not going to happen, that it's politically just too volatile to be able to present at that time. And yet, over just the last couple of weeks, I'm hearing more and more often that it will be released in January. So who knows? We all sit in anticipation. But in the meantime, we know what the rule is currently. And the rule is that investment advice relates to recommendations regarding the purchase or sale of securities. So at least under current law, if it's not a security and you're giving recommendations regarding it, you may not be an ERISA fiduciary. So things like giving recommendations regarding what platform provider to use would not be a recommendation regarding a security and therefore not a fiduciary activity. And you have to meet every one of these 5 steps. And it's pretty easy to meet these requirements because the advice has to be given on a regular basis. So those of you that are operating under a broker-dealer set of rules, you're probably meeting more often with your customer than just once, and so you may be providing advice or recommendations on a regular basis. It has to be pursuant to a mutual agreement. Certainly you're going to have agreements in place regarding your retirement accounts, but it also has to be that the services you provide will be a primary basis for investment decisions. And here's where people find a little bit of wiggle room in that if they're really relying primarily on something else, then they're not giving investment advice or the plan isn't receiving investment advice. It has to be individualized to the needs of the plan, meaning this is not hypothetical. This is advice or a recommendation that is customized to that plan's or that plan participant's actual needs. And gee, by the way, this isn't for free. You have to be paid a fee. So we wait with bated breath to determine how the DOL will change these rules, but this is how they exist for now. We mentioned 338, and 338 is a very special type of ERISA fiduciary, one who gives investment advice, and a 338 must be either an insurance company, a registered investment advisor, or a bank. And the arrangement must be in writing, and therefore you can't inadvertently become a 338. It's only through special appointment and a very special written agreement. If properly done, then the planned fiduciary is relieved of fiduciary responsibility for the investment decisions made by that 331. So this meets a really important need in the marketplace in that plan sponsors are looking for ways in which they can reduce their own liability. So as long as they've made a proper selection of you as the investment advisor, and as long as they provide enough oversight to see that you're performing the services as provided in the agreement, then they don't have to second guess your investment management decisions. So to look at some of the differences between a 338 and a 321, that 321 actually shares responsibility with the plan sponsor in that the plan sponsor retains investment decision-making authority, and the advisor is simply providing a recommendation, which can be accepted or not. Whereas on the 338 side, that investment discretionary authority has been passed over to that 338 manager, and that individual alone can make those investment decisions and will be responsible for them. Now, let's not forget about participant education. Participant education is a really, really critical function in this marketplace. And education is not considered advice. So participant education or investment education can be provided in a non-fiduciary capacity. So a broker-dealer can provide this kind of investment education and continue to receive unlevel compensation in the form of commissions and markups and other kinds of compensation and not be in violation of any fiduciary responsibilities, because if you're not providing a fiduciary advice, then you're not a fiduciary. So looking at the importance of this educational sphere, recent surveys showed that 24% of participants believe that they've saved enough to retire comfortably. So that means over 75% of participants don't think they have enough money to prepare for retirement. So there is a huge gap in the retirement savings, and these people need information about how to comfortably retire for retirement. They need information about plan enrollment, who's eligible, how do I participate, when can I get a distribution from the plan, what are the investment options in the plan, what are the difference in the asset classifications and how do they function. These activities are considered investment information or education and therefore not advice and are provided on a non-fiduciary basis. 16% of workers are confident that their investments will grow in value, so they don't understand very basic investment principles about compounding interest or how investments grow in value over time or how they might lose value, and what is the importance of having a diversified portfolio to help maintain the overall growth of an account. So they need this kind of investment education. And lastly, 62% of participants understand retirement plan fees. And as we dig deeper into this, most plan participants think that mutual funds are free. They don't understand the indirect costs associated with those investments, which are certainly appropriate costs, but they don't understand that they're there. Or they think that their plan sponsor is fully paying for their retirement accounts, and they don't understand that money is coming out of their own investments. So here again, you as investment professionals fulfill a very important role in providing this kind of investment education. Now, all types of these services can be combined in a single retirement-based service agreement. And we think that it's very important that you have one that is specific to your retirement accounts and very carefully describe what services will be available. So you can include those non-fiduciary services, the administrative services. And these are broad-based. They include the investment education that we just discussed. It include helping select at least giving information so that the plan sponsor can select other service providers or vendors for the plan. You can help with providing an audit-ready fiduciary file. You can help conduct the fiduciary committee meetings. There are all sorts of services that can be provided on a non-fiduciary basis. You certainly want to very carefully describe your 321 fiduciary services, those advisory services. And here we suggest that only registered investment advisors can provide these types of fiduciary services. And the reason for that is if we look at that definition of what is investment advice for purposes of ERISA, that 5-point test that we just examined, it looks an awful lot like what is investment advice under the Investment Advisors Act. So we think if you're providing those types of fiduciary services, then you're also probably going to be registered with the SEC as an investment advisor. You can also include in that same contract your 338 services, and if appropriately done, fiduciary responsibility will be shifted to that responsible party. Now, questions come up as to whether or not this really imposes any additional risk to the advisor. And I suggest that you carefully consider this and that it may not impose additional risks. Interestingly, I've had the opportunity this year to talk to a lot of insurance company carriers that provide E&O coverage and that my firm has the pleasure of representing in their E&O claims activities. And a lot of them are looking at adding 338 coverage to their plan, but they're asking me whether this imposes any additional risk. And what I suggest is that if you look at the 321 services, you have the investment professional actually sharing fiduciary responsibility with a novice, because the employer, the individual who is running a successful business and trying to provide good retirement accounts to his or her employees, they're not in the business of making investment selections. And yet, under 321, the typical scenario, they're sharing responsibility. But when you move to the 338, that responsibility is shifting, and you have the investment professional alone making those investment decisions. So you might consider whether there really is any additional risk when you take on that fiduciary responsibility. Gary, did you have anything to add here?
I will. One of the things that I want to caution our audience today is that we often see claims that come from services that weren't being rendered to the client. And the way to sort of have your get out of jail card is to have your contract specifically state in writing the services that you are providing, both the non-fiduciary and the fiduciary, and the things that you are providing. So if it's left up in the air, your client will often assume or make representation that you were providing those services, and as a result of those services that you weren't applying, there was a mistake made, and they'll be looking for you for that recovery. So from a defense panel attorney, an ERISA attorney like Kim, one of the things that they're going to look at is, was it clear and in writing that these were the services rendered and these are the services that weren't being rendered, and is that the ability then to utilize that and say, we weren't doing this, so you really can't find us at fault.
That's a really important point to keep in mind. And what I suggest for your retirement plan services agreements is that you include a schedule that really is kind of a check-the-box format arrangement, so that it's almost like a Chinese menu, and you go down and you, the plan sponsor, can say, yes, I want this service, I want this service, and the contract will include a provision that states that you as the investment professional will be performing only those services that are selected, and that if it is not selected, it's specifically agreed that you are not performing that service. So once you create this check-the-box selection of service choices, there are a whole lot of benefits that can come from that. One is it's clear who's doing what. Just as Gary mentioned, you can expose yourself to some very serious claims if it's not clear what you're not doing. But also, you can identify what are the administrative services and what are the fiduciary services and what type of fiduciary service they are, and then assign the proper legal standard of care to each of those services. So, for instance, you don't have to accept fiduciary responsibility when you're not performing fiduciary services. We think it's also very important that you craft those agreements in plain English. I think a good lawyer today can draft something that is not in legalese. You should not have to translate what is written. And the agreement, like all contracts, should be a guideline for the plan, for the parties to the contract. So it should be something that each of you should be able to read and understand and guide your behavior. Also, when you come up with a very comprehensive list of all the services that might be provided, you're in a much better competitive position, because when your services are laid out next to a competitor, perhaps if you're in an RFP situation, and you've got 37 different types of services that you can be provided that are all laid out in a very organized fashion, you might look very different from the proposal that says that I'm an investment advisor and I'm here to offer advisory services to the plan. You could also include in an agreement negative consent to fee increases, so that people can actually vote with their feet if they don't like a fee increase, but through the right procedure, you can announce an increase when it's coming and not have to repaper the account. It's important that you have representations regarding insurance and bonding, but also important that you confirm that coverage. In many cases, 338 services are specifically excluded from the insurance coverage and have to be separately endorsed in. Gary, I'm sure you have some comments there.
I do, and it's very it's good advice, and you can't assume that if you're doing 321 discretionary work and you decide that you wanted to do discretionary 338 work that your policy is going to automatically include it. And the reason is that you're required under 338 to provide written fiduciary acknowledgement. And within the policy, most policies will have an exclusion that says if you obligate us, the insurance company, to a higher level of liability, that being a written fiduciary statement, then we have the right not to pay claims. So you have to do two things. One is you may have to modify an exclusion with the policy. And then two, you want to make sure that the definition of professional services is wide enough to cover your 338 activities. What we do here is we prefer to actually have it stated and acknowledged by the insurance company that you are providing 338 services. And as Kim had mentioned earlier, many carriers are starting to pick up on this and recognize that it really isn't an additional exposure, but you're the expert, so in some cases can be beneficial to the insurance company.
Terrific. Now, I want to talk to you a little bit about the 408B2 disclosures, but to do that, I want to get into the weeds just a little bit, if you'll forgive this, and talk about what is a prohibited transaction. And the interesting thing here to keep in mind is that a prohibited transaction is, as the name suggests, something you cannot do. And unlike the Advisors Act, where if there is a problem, you can disclose it and get consent of the customer through disclosure, under ERISA, they are prohibited. You cannot do them, and there's no way to get around it unless you can find an exemption. So what are they? And they basically come in 5 major categories, and most of them make pretty much sense. That the plan or a fiduciary to the plan or a party in interest cannot engage in a transaction with the plan that involves, for instance, the sale of their own property to the plan. You know, you can't sell your own assets to the plan and not be in a fiduciary breach. You can't lend money to the plan. You can't deal with employer securities unless, of course, you're following the very specific rules under the ESOP regulations. And you can't deal with anything that is in your interest, self-dealing, rather than the interests of the plan. But this fourth one is the most interesting one because it is actually a prohibited transaction to engage in a transaction between a plan and yourself for the furnishing of goods or services. You think, what? I mean, how can this be? How can it be a prohibited transaction to provide goods or services, and how can anybody then do business with a plan? And the answer is that these prohibited transactions were intended to be very, very broad. And all these activities are prohibited unless you can find a specific exclusion. And where are the exclusions? Well, there are 3 sources. One is in the statute itself. ERISA itself has some prohibited transaction exemptions built into them, and they're in section 408B2. So, surprise, surprise, 408B2 is a specific PTE, or prohibited transaction exemption. There are class exemptions, which are essentially regulations issued by the Department of Labor, and so if your scenario fits that, then anyone can rely upon that exemption. And lastly, if you have unique facts, an individual can apply for a specific exemption that applies only to their unique facts. So what is 408B2 all about? And it says that an individual or a party in interest to a plan, which includes a plan fiduciary, can provide goods or services to the plan if they are reasonable. And prior to the regulations regarding 408B2 that required these disclosures, there was no means by which plan sponsors could really assess whether an arrangement was reasonable or not, because they didn't have the required information to determine, well, what really are the services you're providing to me, and how much are you getting paid for them? So both the arrangement itself and the compensation received for the arrangement must be reasonable. So the regulations were issued after much gnashing of teeth and great consternation within the industry to become effective 2 years ago in July. So the Department of Labor has now been collecting a couple years of data regarding those disclosures, and they must describe in detail the services that are provided, the compensation that is received by for those services, and the status of the provider as to whether or not they're acting as an RIA or as a planned fiduciary. So with this critical information, then for the first time, the planned fiduciaries can make decisions about whether or not the arrangement that you're providing to them is reasonable and therefore not a prohibited transaction. We certainly suggest that while you're having to do all these disclosures, that you might as well just incorporate them into your advisory contracts so that the contract itself meets the disclosure requirements and you don't have to do them separately. A lot of people ask also as to whether or not these need to be renewed yearly, and they do not. The disclosures need to be made prior to the time the arrangement is entered into, extended, or renewed. So therefore, you want to make sure that your advisory contracts are ongoing, therefore they're not extended or renewed, and you give the disclosures prior to the time the arrangement is entered into because it's already wrapped up in the service agreement. So a good way to do that is to make sure your lawyers are drafting the advisory contracts to satisfy these rules. So here's another way of just explaining this, in that you as an investment advisor or broker-dealer are considered a covered service provider, and under 408B2 regulations must make very specific disclosures to the plan sponsor. The plan sponsor, with that information, can determine the reasonableness of the arrangement and make their own disclosure, fulfill their own disclosure obligations. So, for instance, they have to file a Form 5500 and a Schedule C that includes specifics about the arrangement, and the plan sponsor then has to convey additional information to the plan participants in participant-directed plans to meet the 404A5 disclosure requirements. So this schematic kind of helps understand how that all fits together.
Kim, can I just jump in one? Just going back quickly to slide 17, I want our audience to understand that if there's a claim for excess fees, the insurance company will defend you as the insured until such time as it's determined by a court that those excess fees were unreasonable, and then those excess fees are not considered covered damages under your insurance policy. So it basically says you can't enrich yourself at the benefit to you of an ERISA plan and have insurance basically indemnify you for those enrichments. So you have to be very careful. Again, the insurance company will defend you in the event that someone's alleging that you have excess fees or collected excess fees. But it becomes tricky in terms of whether you really have coverage for the damages part. So utilizing what Kim's talking about in a checklist of services, being very specific as to what you're doing, is going to all help in letting your client know that your fees are reasonable based on the services that you are rendering.
Thanks, Kim. We're moving to the end here, so hang on, and we want to reserve lots of time for your questions at the end. We think that another important matter to consider in this ERISA environment is that you have policies and procedures that are specific to the retirement plans. And I kind of like to think about this in four major buckets. So first of all, if we think about the services themselves and the compensation, I suggest that you have specific WSPs regarding those services, defining what they are. For instance, if you're a broker-dealer, are you providing education only? Or if you're an advisory firm, are you providing any discretionary management? You'll want to have some procedures around that. and certainly disclose the compensation that you receive for those arrangements, both in your agreements, which will serve as your 408B2 disclosure documents, and in your ADV, and make assessments as to whether or not those fees are reasonable for your own services. Think about the materials that are used in this particular environment. We've already suggested that you have a retirement account agreement that's specific to retirement services. But let's say you're providing only educational services. Well, who's approving those? What materials are you going to be using? What marketing materials are you using to support this environment? And is the plan going to have its own approved IPS, or how are you going about approving them? If we look at the people that are involved in this process, the advisor itself, how are you qualifying that individual? Will you permit anyone on your field force to sell to retirement plans, or do you want to have some specific rules regarding qualifications? For instance, they've been in business a certain period of time, or they've advised certain numbers of plans or certain sized plans. Do they have any particular certification in retirement services? So once you qualify the individual that's selling to the plan, who's supervising this individual? And do you want to have some specific structure around who's authorized to approve this business for your firm? And certainly if you're making any recommendations for outside managers, how are you qualifying them, and what rules and practices are around it? We've talked about prohibited transactions, so it's very important that you have rules regarding the prohibited activity. How are you watching for conflicts of interest, and how do you identify them? What are you going to do with rollovers, and what are your procedures around those? And how are you avoiding any kind of excessive fees? So it's a good way to kind of think about some of the major buckets of information to consider for your retirement supervisory procedures. All this means that you basically have to pick what business model you're going to be operating under. If you are a broker-dealer, you can certainly provide wonderful services to a retirement plan and meet a lot of good needs in the marketplace by providing education only. This means, however, that you can get transaction-based compensation so that you can provide for markups. You can get commissions that vary by the basis of the products that you are offering, because you're not acting in a fiduciary capacity and are not bound by the conflict of interest rules. If you're not comfortable serving in a fiduciary capacity, you can certainly make recommendations to outsource those services to others, and you can freely engage in rollovers. On the other hand, if you're on the broker-dealer side of the equation, you can provide education and advice, whether that be discretionary management or recommendations only regarding the securities. But it's very important, we believe, to have good agreements that describe what those services are. You can either share fiduciary responsibility with the plan sponsor, as you would in a 321 arrangement, or you can accept more of that fiduciary responsibility for yourself in a 338 arrangement. But here you are acting as a fiduciary. You therefore must avoid conflicts of interest, and you therefore cannot benefit based upon the recommendations that you make or the discretion that you exercise. Accordingly, the best way to avoid that is to have all levelized fees, so that no matter what your advice is, you're going to be paid the same, and you're not going to benefit by getting paid more from one mutual fund or another that is the subject of your recommendation. You can certainly allocate your fiduciary responsibilities with other fiduciaries, but you do have to avoid any conflicts of interest or self-dealing. So this is kind of a way of looking at the various business models that might be offered.
Kim, it's Gary again, and just on that last slide, the thing I might point out to the RAs and the broker-dealers that are listening today is that you need to do your due diligence when you outsource any activities outside of what you're doing to other fiduciaries. And by that I mean that if you're going to make a recommendation, you should obviously do their credentials, due diligence, and other things, but you want to check to make sure that they have the appropriate E&O insurance in place. If they have discretion, you want to make sure you're bonded. As a fiduciary, you can't just look the other way. You have responsibility to the plan to identify someone that there's a weakness, and you also can be attached with vicarious liability in that if you recommend an individual to take, say, a 338 role and they're not properly bonded and they make mistakes, it can backfire on you. So you should do your due diligence. One of the things that we see often in my office is someone will say, well, I have discretion under my insurance policy. But when we review the policy, what we find out is that discretion is limited. It may be limited to mutual funds. It may not be limited beyond that. Or there may be a product that's specific to a plan that's in the best interest of the plan, but is excluded under the policy. So making sure that you have the right coverage becomes paramount when you're making recommendations to others.
Those are great points, Gary. And two things to add to that. From a legal perspective, we've talked about how one can pass fiduciary responsibility, but there are a couple duties that cannot be delegated, and that is, first of all, as Gary's already pointed out, you have to make sure that the recommendation is appropriate to begin with. So you do have to do your appropriate due diligence. And also, once that recommendation of another provider has been made, you do have some oversight to determine whether or not the services are actually being performed as stated in the agreement. So it doesn't mean, for instance, that the plan sponsor has to second guess the investment decisions that are made by the 338, but they do have an obligation to make sure that the services are actually being performed, such as by getting appropriate reports and reviewing them and making sure that they're doing the things that they said they were going to do in the agreement. And you can help your plan sponsor clients fulfill those obligations by helping giving them the information they need to make those determinations. Gary also mentioned, go ahead.
I'm sorry, we just got a question and we're responding back, but I think it's a question that might be on a number of viewers' minds. The question is, do I need specific policy bonding if you're acting as a 38? So the bonding question is, yes, you need a specific bond that covers all the plans that you're acting as a 338. And it's the same bond that the plan sponsor will buy, except it's on you or any of your employees from stealing from that plan. In regards to the E&O, you don't need a special E&O form, but you need to make sure that the E&O coverage includes your services as a 338, as I talked to before. The bond is essentially a third-party bond. That is correct. It's covering the plan from theft by you, the advisor, or any of your employees.
And Gary's got some great information about this out on his website, but there is some confusion, I think, in the marketplace to understand that there is a difference between the required fiduciary bond and E&O coverage. Two different things. So please start submitting your questions because we really are about ready to wrap up, but wanted to talk a little bit about what we might see on the horizon. One very important point to keep in mind is that those 1,000 new enforcement agents are looking at those 408B2 disclosures. The DOL is making a very intense review of them, and they themselves create a roadmap for what might be going on. For instance, if you are acting as an advisor and yet the disclosures show that you're receiving different forms of compensation, then you may, on its face, be providing evidence of a prohibited transaction. And we can be assured that plaintiffs' counsel are also reading those disclosure documents when they get them. Rollovers will continue to be very, very heavily scrutinized, and we do recommend that you have specific policies and procedures regarding who can engage in a rollover and how that activity must be conducted. We're going to see a continual compression on fees, and we feel that it's important that you do appropriate due diligence on the fee structures for the products that you offer and have some structure around what you deem to be appropriate fees. Training is of utmost importance. We feel that if agents, representatives are going to be operating in the ERISA context, they should have specific training on ERISA services. And all of the regulatory releases emphasize the importance of training in each of the areas that has been the subject of those releases. We know that all plans have to act prudently, and prudence generally means having a repeatable process that is fair and reasonable, and that you have procedures around them. So not only should you as a firm maintain appropriate procedures, but you can help your plan sponsors by providing some guidance on what procedures need to be in place also, or give them the information that's needed to help support their own procedures. And with regard to 338 and 316, we think there's going to be a growing acceptance of 338 services. I believe that insurance coverage for these services will expand very soon. I already have quite a few insurance company clients asking about them. And trailing way behind them is 316 services, which is a similar process by which the plan sponsor can delegate plan administration services to a third-party provider. We're really at the cusp of that. I've written on that topic. Gary has some great materials out on 316, and as he mentioned, he and I will be speaking on it soon at the Center for Due Diligence conference. But we're probably at the very beginning of what is the next 338, and within a period of time, I think it will be equally accepted in the marketplace to provide those types of services. And Gary, let you wrap it up.
I do have a question. I'll read the question. Are there any court cases that highlight the danger of missing conflicts of interest or self-dealing? Sort of the first part. And the second part, we see lots of RIAs accepting rollovers, accepting fiduciary responsibility, and then taking on participants as non-fiduciary roles. So I'll let you answer that, Kim.
Yes, there's lots of case law out there regarding missing conflicts of interest or self-dealing. There's certainly regulatory actions that the DOL has brought, but we also have a very long string of cases regarding excessive fees. And there we're looking at the plan sponsor's obligation to accept arrangements that only provide reasonable fees. And along with that, there have been cases such as Fidelity and a few others where the provider is either the plan sponsor itself or otherwise benefiting from those. So yes, there's case law out there. And there are arrangements in which an RIA can certainly provide for rollovers when they're advising the plan. But it's likely a conflict of interest to receive fees for both the assets when in the plan and then charge the participant an additional amount to advise them. So there are sometimes providing those on a non-additional cost basis or providing services to the participants that are educational only and therefore staying outside of a fiduciary role.
Kim, another question is, am I a fiduciary if I provide specific investment advice to a participant, but I'm not paid for by plan assets?
No, I don't believe so, because the fundamental question about a prohibited transaction is a transaction between a party in interest and a plan. So if the plan is not paying for the service, then it's not prohibited. So the participant can certainly pay with external funds for the advice that they feel that they need.
Terrific. So this session has been recorded. We will be sending a link in the next day or so out to the registrants so that if they feel they've missed anything or want to review it or certainly pass it along to their colleagues, we'd be happy for you to do that. You'll see that the next slide Kim has provided, connect with her on LinkedIn. We can answer additional questions via email, either to myself or Kim, if you have questions that you weren't able to ask and or start to think about afterwards. We thank you for attending this. We hope that you find that there was value in it. And again, in a day or so, you'll receive the link with the actual recording where you'll be able to view it again. Hope to see many of you at CFDD at Kim's and our presentation on 3/16. Thank you very much.
Thanks, all.